And thank you for the interesting questions as well. Actually, I realized that we should have inversed the sessions. This morning, we had 2 sessions on real-time standards and accountability of cloud services, presented by the NIST, and the second presentation from a European project called NG-CERT, which is also aiming to show a perspective in same topic, which is real-time accountability and visibility of the health of systems in cloud services. And I think probably a combination of the 2 topics would have been appropriate. I would like to welcome on stage the participants of the next panel, which are going to be, again, Mr. Vievorovski. Thank you for accepting our invitation. A representative from the Romanian Data Protection Authority, Mrs. Simona Sandru. Thank you for accepting to participate to the discussion. Václav Mak, Government Affairs, Microsoft, Central Eastern Europe. And Bogdan Manolea, a Romanian legal expert in data protection and a fighter for digital rights. Long time. Okay. We are going to share one microphone for the speakers. I tried to use the integrated headset, but it's too complicated. Technology is too complicated sometimes. So I propose to you to have as a topic for our discussion in this panel the international data flows. I realize the time is too short to get into the depth of the topic for, first of all, for Europe, because it is very complicated to have 28 member states which do have independence over regulation in the same time, but also to reach a common approach on a European level, which is going to be ensured by European Data Protection Supervisor, by the next board, which is going to come into being in 2018. And as we do not have enough time to get into the depth, we are going to try to throw an international perspective over how data is being circulated between continents and how is this useful for economic development. It is certainly useful, so we want to be part of the global economy, the global digital economy, but at the same time we have to deal with serious topics and complicated topics as the technology keeps changing, keeps evolving. The discussion is going on around transparency, accountability, real-time certification, because customers want to be sure that they have the appropriate tools in place and the appropriate tools to measure the quality of the service and the kind of treatment they receive from their providers. So, as of this year, next to the adoption of the GDPR on European level, we have seen also the signature of an international agreement between Europe and the United States, which is the EU-US Privacy Shield. Why has this new agreement been signed? Because, well, there was a kind of legislative void for international data transfers. Companies transferring data between Europe and the United States were in a difficult situation after the previous agreement regulating data flows had been invalidated by the European Court of Justice in the Schrems case. So the legal void has to be filled somehow. We cannot operate in uncertainty and risk, have risk in our businesses as cloud providers, and also as data subjects, as you call them. So how is this agreement going to work? I'm going to address this question first to Mr. Vievorovski, because he has certainly been involved in creating this piece. And what are the requirements that this new agreement brings between the two supervisors, to say, the two states?
Well, let's clear up the situation at the beginning. We can talk about agreement between United Europe and United States, but this is rather the colloquial way of dealing with the subject. From the formal point of view, this is not the international agreement. This is not the international treaty. That is only a kind of agreement on a scam that exists in the United States and which is purely internal solution by the American authorities for the American market, which has been recognized by the European Union as being adequate to what's going on in Europe. So there is no treaty that was signed by both sides. There is no agreement that was signed by both sides. There was the line of the discussion between the EU representatives and the USA representatives, which led to the situation when the number of documents has been prepared on the American side. None of them is a law. That's once again an important thing. None of them has been passed by the Congress. None of them has been passed as the official legal act in the United States. These are internal documents of the administration that the administration can do in their capabilities. And that's a self-certification scam for American companies. And on the other side, we have the decision from the European Union. So once again, the unilateral act of the European Union, decision of the Commission, which recognized the system as adequate to the requirements of Europe. So, in practice it means that as long as somebody is in the system prepared in the States, is able to get the data from the European Union, countries from the European Union controllers. How it will work in the practice, that's a good question that we will see actually in the nearest future. At the moment we have about 250 companies who are certified as the users of the Privacy Shield. Last days we have the decision from Google to join Privacy Shield as well. But actually the general opinion is that when we will have about 1,000 companies, it means that the program is really operational. And please allow me not to answer the question if anybody will send it back to the Court of Justice. I don't know. I don't know, but I think there might be the people who would like to challenge this system in the court as well.
Yeah, I would like just only add that we have been involved in the discussions before the Privacy Shield happened. I think we were very close to the team of Věra Jourová, who was negotiating what's supposed to be within the scope of the Privacy Shield itself. And I'm proud that Microsoft was on the 1st of September, if I remember, one of those first companies who were officially announcing that they would like to lead by the example, and we signed for the certification through the Privacy Shield. Definitely the most important will be situation 1 year after, once the review of how it works will be done, and this is something where definitely we would like to cooperate on how to improve the Privacy Shield in the future as well.
So basically Europe is asking the United States to comply, to kind of raise up to the standards that we accept as in data protection, and this will have to be accomplished in the future. So Mrs. Simona Chandru, thank you for joining us as well. I would like to know what the view of the Romanian data protection authorities on this topic. How do we deal with international data flows? Do you participate also in the discussions on European level?
Thank you for the invitation, first of all. Romanian DPA is part of the Working Party Article 29. Mr. Vievorovski just mentioned a few minutes ago. So we are closely follow our colleagues from the other DPAs when they are assessing international transferring to other states than European Union. As for the Privacy Shield, first of all, I'd like to say that after the Safe Harbor Principles decision was invalidated by the European Court of Justice, the Romanian DPA has no longer permitted to use this legal instrument as a guarantee for transferring personal data to the United States. But anyway, data controllers, data exporters still might use the other tools, such as standard contractual clauses or binding corporate rules. After the Privacy Shield decision was adopted, we take some steps in order to inform the general public of the new legal framework that is in place, in order to make sure that transfers to the companies in the United States are legal and in accordance with the EU principles. So we made some changes to our notification guide for data controllers, which is published on our website. And also we posted on our website the European Commission guide for the citizens. So any Romanian citizen, for instance, make use of the mechanisms which are put in place by the Privacy Shield decision in order to complain about the legality of any transfer of his or her personal data to the United States. It is very early, as Dr. Wieworowski just said, to make any assessments of how the things were going on. It is only the 1st of August, I think, that the companies could list on the Privacy Shield, list on the website of the Department of Commerce in the United States. So we'll see.
Yeah, we will see. So, in our opinion, until we manage to reach an internationally accepted, commonly accepted global standard in data protection, the problems are not going to stop. We are going to keep fighting each other, and companies will have uncertainty while operating. So it is necessary to have a continued collaboration and dialogue in order to solve these issues. Bogdan, any opinion on that?
I'll be more direct in two ways. First, I think that Privacy Shield is a failure. It's a failure from a political point of view, because even though it was presented as a success by politicians, especially from European Union, it's not. It should have been an international agreement between European Union and United States on data protection issues and on transborder data flows. If this doesn't exist, the rest of it is peanuts, and it wouldn't work in the long term. And we've seen what happened to the safe harbor. We've seen that the action of one person who went through a great deal of legal complications in order to prove in the European Court of Justice that safe harbor was totally wrong, just created chaos in the industry and on everyone. So that's one thing. I really think that Privacy Shield is a failure, and we should just look, and whenever we talk with politicians or with MEPs or whatever, we should just ask them, when will a EU-US data protection agreement be in place? Because that would be the only way that will solve things on the long run. The second thing that I would say is that, like it or not, I think at least 50% of the companies that are presenting here today, down there, are transferring data to US. And not to companies that are part of the Privacy Shield, and not to companies that were part of the safe harbor. They are just transferring the data. Some of it is personal data. Maybe some of it is not. Maybe they don't know exactly which one is personal data and which one is not personal data. So I think it's a major disconnection between reality and speech in terms of data protection. And we need to face that before it's too late, because otherwise we'll sit on a nice panel and talk about it, and actually the companies will just transfer the data from one way to another. And that's something that needs to be taken seriously more in practical terms. In practical terms, meaning functionable code of conduct and certification that actually work and are understandable for both users and companies. I mean, also the user is in a total chaos today. He doesn't understand anything about the cloud or where the data resides, and if he has a problem, usually it's too late. So unless we solve this problem of presenting the data protection in a more easier way to understand for companies and for users, I think we're having the wrong discussion.
That could be especially true for SME type providers, which do not have probably the means or a way to understand the regulation, to apply the regulation. They do not probably manage to follow the whole range of obligations that they have to comply with. Of course, global providers have different view and different means to approach the legal topics and obligations. I would like to go back, because this is a reason for me to go back on the European implementation, as we are pretty much leading the field in data protection worldwide. We think that our way is correct, and we think that the world should listen to our approach. We have a new piece of regulation that is going to come into effect in 2018. How do we manage to get up to speed as an industry? And I'm talking here not only about the global providers, which do read and do comply and do manage to put the resources that are necessary in place, but how do we deal with the SME type of providers, the small industry that creates 90% of European providers' economy? How do we help them? We have issued a recommendation, as well as Eurocloud Europe, to publicize the key issues, to talk more about it, to make sure that we do not get into a situation where in 2018 we see that data protection authorities start to fine companies, and I understand the fines are quite elevated, quite dissuasive, as just as the Network and Information Security Directive is proposing dissuasive fines. We have to make sure we work together and we enable the industry to follow the new regulations. How do you think this will be possible? Are there any kind of instruments that can be put into place?
I think...
yes, Chandra.
We also encourage the industry to draw up or to adhere to some codes of conduct, especially when we're talking about cloud services. It is a very important tool of self-regulating this kind of activity, and we encourage everybody to do so. Our role is to advise them, and if it will be about trans-border processing, then the future European Data Protection Board will be responsible for assessing the legality of these codes of conduct. For the implementation of the regulation, we already recommend in our written correspondence with data controllers or public authorities which are drafting some new legal instruments, which concerns also data protection, to already adapt their activities or their regulations to the new provisions of the GDPR. It is very important to be ready to deal with the challenges which are made in this regulation.
Are we going to deal with 28 code of conducts again, or is it possible to coordinate this approach on a European level? A question to Mr. Wieworowski.
I'm afraid this is not a question to me. This is a question to business. Because if you ask if we can coordinate the opinion of the data protection authorities towards the codes of conduct, of course, there's no problem. We are doing it on an everyday basis. There was an opinion to the code of conduct prepared by the group that I was talking about the cloud. Right now we had the opinion about smart metering code of conduct. We have an opinion about RFID code of conduct. So there are definitely the things which are going on at the same time. What we see as a problem is the fact that it's very hard to create the code of conduct for all Europe. If we take into consideration the experiences under the directive from 1995, you can find out that there was only one all-European code of conduct that was prepared. That was the FEDMA one about the direct marketing. And the problem was not on the side of the Working Party of Article 29. That was not the Working Party of Article 29 which was slowing the process. No, simply no draft codes were appearing. While at the same time we had quite a lot of codes of conduct on the national level. In Ireland, in the UK, but also in my country of origin, in Poland, we had a dozen of codes of conduct for different sectors. It was easier to do them on the national level. It was much more difficult on international level. And for me, always the best example was the pharmaceutical industry. They started to prepare the code of conduct on data protection in 2007, and they do not have a draft until today. Yeah? Because it's not easy to sit at the table and to prepare the draft like that. I'm very happy that's why I shown you this code of conduct that was prepared for the infrastructure. Yeah, I'm very happy that it appeared. There are the things in the code which I don't agree with, but I'm happy that it's on the table because there is something to talk about. And for me, it's absolutely normal that for cloud computing, that cannot be the national solution. It has to be the international solution. On the other hand, if we are going to wait for the treaty about it from the side of the governments, then we will wait forever. Because first of all, it's extremely difficult to prepare the legal act like that. Secondly, these are not the governments to propose the things like that. So that's why I come to Eurocloud Forum. Because I believe that Eurocloud is one of the platforms on which such codes of conduct or such codes of good examples may appear. So I strongly encourage you to deal with it, to take part in such activities, because only this kind of self-regulation may help. And let me address the thing which was said about the privacy shield a while ago, that as long as we will not have the international agreement between United States and the EU, that will always be a failure. Well, I would love to have it as well. Especially as a constitutional lawyer, I believe that it would be the good solution. The problem is that at the same time, Americans do not have the tradition of the international treaties like that. This is simply not the matter for the international treaty on the American side. That's also why we have the discussion with TTIP or even with CETA in Canada, but TTIP first of all, which is not the international treaty from an American point of view. That's an agreement only done by the administration. So I would love to have the solution that you say about, but I'm afraid we will not be able to reach it because of our American partner, from the formal point of view.
Just a comment to the implementation of General Data Protection Regulation. I think there is a lot of requirement to the cloud providers, but there is also a lot of not readiness on the customers' sides. And of course, there will be need of the more and clear, transparent way of propagation or promotion of what has to be done in the time frame until 2018. Because there were some surveys done on the industry associations or chapter of commerce, where they tried to ask the big companies such as banks who already, for example, are dealing with the data protection, and they knew what to do. But then there is a lot of small, medium enterprises who has no clue what the final impact to them should be. And as you mentioned, the sanctions for them should be very significant, and that could be something what simply can influence their ability to be on the market and to compete on the global markets as well, because they'll be facing the regulation which some of their competitors outside of the European Union will simply not do. So because of that, we have to be also very much thinking of how impact of the general data regulations can impact the international, I would say, competitiveness of the small, medium companies on the European market.
I'm not going very much into the discussion of the US-EU treaty because it will be a long one and a complicated one. I said that it was a political failure. That was the point, because there were some political figures who claimed that they are working on that and that they will have it ready. So it wasn't. It was a political failure. It wasn't a success. On the codes of conduct, I think we need to be realistic, and I don't think that codes of conduct for SMEs work. And I'm saying that as with my other hat as an e-commerce trustmark company. And we didn't go into the codes of conduct for two reasons. First, the SMEs have no expertise into the field. so they wouldn't know exactly what to negotiate, what to put in there and what not. The second one is that there is no enforcement of the code of conduct, a real enforcement. So therefore, it's really something that it's useful, I think, for big companies, for someone that is more used to this kind of soft rules, but not for SMEs. I think for the SMEs, one of the solutions, and there are several of them, is the data protection officer. Even though the final version of the GDPR does not mandate the data protection officer for SMEs or for private companies, well, with some exceptions, but generally it's not an obligation. Although, if I remember correctly, in some earlier drafts of the GDPR, it was a much clearer obligation in this sense. I think that's the way to go forward. Because if you have a data protection officer, or if you delegate that part to someone that does the data protection things, at least you have the capacity to create this kind of expertise and knowledge. And this can be done in an SME association as well. However, what it is complicated is to create the data protection officers, at least talking from the Romanian field. I think that right now we have a great lack of data protection experts, and therefore a lot of discussions that I have sometimes with companies or state authorities go back most of the times to the mere definition of personal data. So if we don't know what is the personal data, and the guys that are working with personal data have no idea what that is, and you come up to the question if the address of a company is a personal data, then there's no need to talk about complicated things. We need to go back to the basics, learn the basics, create the expertise, and then go forward.
Yes, indeed. The aspect of accountability towards data comes from understanding what data is. It's for sure a key topic. It is interesting. I think we are heading into. We are starting to see a path towards 2018, and I think this comes with a lot of awareness raising, with codes of conduct, with education, but also I would like to raise the question of data breach notification tools. So there will be data breaches, there are data breaches. They happened and they will happen because that's life. But how can we make sure that the industry, the providers, the ones that are dealing with data have a easy and understandable way to notify these breaches? Is there any work in progress happening on that field?
We may start from the general information that data breach notification systems exist in the world in many places, and there are the experiences already gathered. Surprisingly, this is the part of the solution which has been actually imported to the European law from American law. Right now we have already data breach notification systems in the USA. Surprisingly, it's not the harmonized system in the States. There are right now 51 solutions in 47 states and 4 territories, plus 4 states which do not have any data breach notification. So it cannot be more complicated than it is in the States at the moment. But we have also the experience in UK, experience in Ireland, and what is very important, we have the experience in the telecom package already. So the data breach notification exists in the telecom market, and this experience were gathered on the national level in all 28 states of the European Union. What does it mean then for the future? Well, definitely the system of data breach notification have to be simple, have to be electronic. These are the things which are almost sure for everybody. Yeah? It has to be simple and it has to be electronic. Why? Because the main reason for that is to be aware what is really going on in the country. What is really the scale of the problem. Because right now, the data protection authorities can see only the peak of the iceberg. They do not really see what's going on the lower level. So the important is to make it electronic, make it fast, and assess the severity of the data breaches that happens, differentiate it because of the severity, and what is, I guess, also very important, to make it sure that the information shall be transmitted when it is possible, as soon as it is possible, even if the information is not complete. So then there was a possibility to fill the gaps and to supplement the notification that was done. The experience from Ireland, the experience from UK show that if we make the data breach notification too broad, let's say, then the Data Protection Authority starts to become the register of the lost pen drives. That's what happened in Ireland. Yeah? The most of the register of the data breaches was the register of the lost pen drives. Moreover, in most of the cases, they didn't have even a clue if there was any data on this lost pen drive. But in case, there was an information sent to register. And the last thing that I would like to be in mind, and I would like to drive your attention to, is the fact that breach notification exists, as I said, in the telecommunication law, but right now it also exists in ADAS regulation. So also in the regulation about the electronic signature and identification. And, of course, also in NIS directive. So we have at least 4 systems that exist at the same time, and we didn't manage to harmonize the deadlines, even, in this. So we have the problem of the harmonization of the system. The only thing what I can say is that this is not only a European problem, Americans have exactly the same problem.
Yes. If I may add a few words on that. In Romania, I think there are already 3 years since Romanian DPA has put in place a system of notification of data breach notifications in the electronic communications sector. We have on our website a decision. We issued a guideline for notification and a special form to be filled out electronically using the electronic signature by the data controllers. It is a problem how to find out if you are breaching personal data, if I understand correctly your question. We as a DPA find out very often about data breaches from complaints. So in these cases we might see there could be a bigger problem than just an individual case. So for us it is a very important tool, the complaints we receive on possible data breach security.
Do you receive a lot of complaints?
Yes, a lot. Only this year, in the first 6 months, we received more than 1,000 complaints. This is the total number of the last year.
I want to say 3 things about the breaches. First, there is a tool, if I remember correctly, that ENISA is working on and they have a lot of best practices documents as well on their website. But that's about security breaches, and that brings me to point number 2, that sometimes we mix or we fail to understand if there are differences between the security breaches that need to be reported and data protection breaches that need to be reported. And that's a pity because, as it was mentioned earlier, we create several laws with several different obligations which confuse people or businesses that need to report them. So just in the case of the e-privacy directive, where it was included the data breach notification for electronic communication, the decision in Romania is that for one security breach that includes also data protection breach, you need to make 2 notifications on 2 different forms to 2 different authorities. And you may expect 2 different answers. That's not normal. It needs to be unified and it needs to be shared information among public authorities. The third point that I wanted to make on data breaches, I think we'll be in the unlucky position that most of the companies would learn by the hard way. So either they would receive a fine, a big one, on this, either they would see a big fine being applied, hopefully, to a major data breach, and they would realize it. And I can tell you, I saw this example with the cookies, because even though we had some discussions related to that, but one result of the fact that the Romanian DPA had some quite big fines for Romania on cookies is the fact that whenever you talk to people about their website, they always say, oh, and there is this cookie thing that I need to do. I don't know what it is, I don't know what I need to do, but I need to do it. So that's one way.
Indeed. As I was saying, this morning we had sessions on standardization, real-time accountability projects that are still research projects that are happening in the cloud field. And it would be interesting to see in the future an electronic tool that would notify in real time the data breaches as they happen, if there are such capabilities to do that. But that will certainly be work in progress, and we will see that in the next years. With that, Václav?
Definitely cloud will help in terms of developing such a tool. On behalf of Microsoft, I think we have very good experience with the vulnerabilities in the systems and how to fix and do the virus protection, for example. So those kind of the IT kind of sharing the information systems are the most efficient way which can help to protect. And this it's not only about the announcement about the data breaches, but also being able to react. And that's why the systems is very important.
Yes, indeed. And with that, I would like to thank our guests for this panel, for the very interesting discussion. And I'm happy to take quite a lot of valuable pieces of homework in my backpack for the next couple of years that I hope to solve with your help and with the help of the industry, of the research sector, and of the policymakers and the data protection authorities. And I know that I saw a few raised hands in the room.